Good morning, good afternoon, and good evening, wherever you are. So, today we are going to explore a piece of legislation that laid the foundation for modern digital privacy, the European Union Data Protection Directive, officially known as Directive 95/46/EC. Now, even though this directive has been replaced by the GDPR, its principles and impact remain absolutely essential to understand today's privacy framework. So, this directive was adopted in 1995, right at the start of the internet era. Its goal was to protect the fundamental right to privacy in relation to the processing of personal data and to ensure the free movement of data across EU borders. It was a directive, not a regulation. That meant each EU member state had to implement its provision through their own national law, and while they gave flexibility, it also created inconsistencies across Europe. These inconsistencies eventually become one of the main reasons why GDPR was introduced year later. The directive established seven guiding principles that shaped global data protection law. The first must be fair and lawfully. The second principle is it should be collected only for specific, explicit, and legitimate purpose. The third is minimum amount of data necessary should be collected. The fourth one is data must be accurate and kept up to date. The fifth one is it should not be stored for longer than necessary. The sixth one, appropriate security measure must protect the data, and the final data controller must made responsible for ensuring compliance. If these sound familiar, that because these principles carried out directly into the GDPR of Article 5. One of the directive most groundbreaking aspect was that it empowered individuals known as data subject. For the first time, people were granted right to be informed, right to access, right to correct, right to object. These shift gave individual real control over their personal information, something that was revolutionary at the end. On the flip side, organization called data controller had clear duties. They ensured that processing was fair, legal, and required clear consent. And they also had to implement appropriate security measures to protect the personal data. Another interesting requirement was that certain type of data processing had to be notified to a national supervisory authority before they begin. This was an early version of regulatory oversight. Now, while the directive was groundbreaking, it wasn't perfect. It faced some serious limitation, like each country implemented it differently. Rules were not consistent across the EU. It was written in the mid 90s, long before smartphones, cloud computing, social media, so it simply could not keep up with modern technologies. And enforcement was relatively weak, penalties were very low, some organizations did not take it seriously, and the result is a fragmented system often frustrated both business and the individual. So by the early 20s, it was clear that the directive was outdated. That's when the EO introduced the GDPR, that is General Data Protection Regulation. The GDPR took effect on 25th May of 2018, solved many of the directive weakness by directly applicable in every EU member state, no national transposition required, introducing uniform rules across Europe, providing much stronger right for individual and introducing tougher enforcement and massive fines. GDPR was built on the foundation of this directive, but it modernized and strengthened in for the digital age. To wrap up this, the EU directive was a pioneering law. It created the very first framework for protecting personal data on a continental scale. Its influence went far beyond Europe. Many countries around the world model their own data protection law based on these principles, and it has now been replaced and its legacy live on it the GDPR. So when we talk about GDPR today, we really standing on the shoulder of this directive. Thank you for joining me in this lesson. Now move forward and see how GDPR took these principle to the next level.